you.
We have George Saldana. George Saldana here. And your affirmation shows that you are George Saldana here on behalf of Interference with Child Custody Group Texas and yourself, and you're neutral on the bill, correct?
Yes, sir. Can you give some copies? Do I start when
Go ahead,
when
yes,
you
sir.
finish? Okay. My name is George Saldana, and I'm going to go neutral on this bill. What I've given you is the Texas District and County Attorneys Association meeting we had here in Austin. Representative Richard Raymond set that up a few years ago, trying to go over interference with child custody. It's a state jail felony. We've met with DAs from across the state to have this enforced. I'm sorry, I'm out of breath. But as y'all know, this isn't getting enforced. I encourage you to talk to your DAs in your county to have this law enforced. Now, pertaining to the bill is going to amend the B portion of interference with child custody. The B portion talks about entice or persuade the child to leave the state. The issue we're having is on the A portion. The A portion is takes or retains the child in violation of a court order. So while I believe this is a good step moving forward, what we're doing is we're gonna, and I hate to use the word limit, but we're gonna kind of limit the felony to a misdemeanor when another parent entices or persuades the child to leave the state. If we can't enforce these court orders on the state level because DAs are not taking this charge under the A subsection, how are we going to enforce the B subsection with the enticement or persuasion of the child to leave the state? I don't know how many of y'all have ever done a UCCJEA motion or a petition, right, to obtain a child. Was that my time limit?
Well, you got about 20 seconds.
Okay, I'm sorry.
Kind of wrap
So the enticement and the persuasion, you can't really entice or persuade a child to leave the state until you actually have obtained the child. So if it's there a retention or a taking or a retention, then it's kind of, I don't want to say useless to try to modify the B portion, but giving it a misdemeanor 500 civil charge, okay, you're lowering it down from a felony. The reason it's a felony is because you need federal law enforcement to travel outside the state to obtain the children and bring
Okay,
them back.
we've got, Ms. Jones has a question.
Yes, ma'am.
I've got a question. So you said that the section, it's already too late because they actually would have them kidnap them or whatever before you get this. What would be your fix to that, if there was one?
Honestly, and in my experience working with parents that deal with this issue, the simple, most cost-effective solution is to have law enforcement mitigate the situation out in the field.
What does that mean?
When they mitigate the situation, they look at everything that's being presented at that scene. Is it hostile? Is it non-hostile? Right? If it's non-hostile and the dad has a valid judicial court order, why are we restricting their fundamental right to their child? And so with this, you're talking about enticing or persuading the child. And that's what this bill goes over. And it says to leave the state. So if a parent picks up their child and moves to New York, now the father has a hard time trying to enforce this order, much less enforce it here than in New York, because there's no jurisdiction. If you go into the history about interference with child custody, the reason it's a felony is because when it was adopted before the UCCJEA came out, the federal law. And so the UCCJEA, Uniform Child Custody Enforcement Jurisdiction Act, sorry, I ran over here. It was legislated after, I'm sorry, the history. It was legislated after the whole issue. Law enforcement didn't want to get involved with these issues, so they kept saying it was a civil matter.
So most times when something like that happens, when it's a child custody issue, law enforcement comes out there and they say, hey, you got to go to civil court. This is a civil matter, right? So I understand that, but I think that it's not always easily ascertainable what's happening at the scene, right? For example, if it's a domestic violence situation, then it could appear from the outside looking in like it's not hostile when I just got beat, right? And I'm afraid to say anything. And so when the police are out there, I don't say anything. So I think that's hard to figure out for police. But what I'm trying to figure out from you is, are you saying, I don't like this? I know you're neutral, but I don't like this because it doesn't allow the police to do something at that moment. And I think I think X is the remedy. Can you give us a remedy that you think would work?
Again, I believe when you mitigate the situation, we all have the presumption that we're innocent, and it's even in the family code. And if you look deep into the family code, interference with child custody is domestic violence under the title. Under the title it's under, there's a presumption there that it's domestic violence. So while we're trying to protect victims of domestic violence, it's also domestic violence to keep or retain the child.
And let me be clear, part of my practice is that I practice family law. And parental alienation is bad, whether parents realize it or not. Keeping your child from one of their parents, it's going to manifest itself eventually. The child might not be able to figure it out when the child is younger, but when they get older, trust me, your child's going to have issues. I was just trying to figure out what your fix is, and it seems to me you're saying that officers should be able to do more at the moment in time that they're called out, and that's your fix.
Well, the government code, the family code has a specific statute that says every court order must have, the legal, any peace officer of the state may use reasonable efforts. Reasonable efforts, and we talked to the Senate yesterday about contempt orders. Reasonable efforts are trying to mitigate the situation in the best interest of the child. And so while someone has claims of domestic violence, there are legal remedies they can use. They can use, and Harris County, I'm very familiar with Harris County. There's AVDA, there's other resources out there in which they can use to obtain the correct mechanism to take or retain the child legally.
So I think you answered my question. Thank you. And I would like to thank you for bringing up AVDA, which is Aid to Victims of Domestic Abuse. It's one of the organizations that I believe very strongly in. But thank you. I think you answered my question.
Thank you.
Thank you. Mr. Cook?
I just want to confirm, what part of this bill do you not like? I don't think this bill says what you're saying it says.
If I can read it, an offense under subsection B is a Class C misdemeanor punishable by a fine of $500. Right now, it's a felony. It's a felony because when you take a child out of state, that's an issue.
But that's the part that you keep saying out of state. It's not required that it be out of state.
It says at the bottom.
Under this bill.
It says number 2, entices or persuades. I have the bill here if I can show you.
I've got it right in front of me.
It says number 2, enticed or persuades the child to leave the state.
What
It's
section?
Right above section 2. But that brings an important question. What about for people in state when they persuade or entice the child to leave the custody of the parent here in the state of Texas, whether it's Dallas, Houston, Fort Worth? I understand removing the felony when children are being taken over crossing the lines. I think the safeguards in the constitutional safeguards to protect the child, and you have a legal remedy in civil court and you have a legal remedy in criminal court. And your civil court's not going to go pull the other parent from New York to bring the child back for a $500 misdemeanor. So you need that felony bite. But again, if parents like myself are having a hard time because the other parent is retaining the child or taking the child in violation of the court order, this right here.
The point I'm making is that you can you're talking about the punishment, but I'm talking about the crime itself. It does not require that the child be taken out of the state. What you're talking about is the punishment level goes up if the child is taken out of state, correct?
Well,
that's the point you're making, is that based on the way the bill is written, is that if the child goes out of state and it's on the first occasion, it's not a state jail felony like it is currently. That's the point you're making.
Currently, it's a felony.
That's what I just said.
Yes, sir.
Okay, thank you.
Okay, any other questions? Okay. Thank you for being here.
And I'm sorry, I forgot my shirt and I was running late and there was a car accident.
You look great.